Okay, so last time we were looking at resulting trust, and today we're going to look at a specific type of resulting trust, the type B resulting trust. So where property has been transferred on trust, but the trust cannot be performed, for example, for lack of certainty of objects or perpetuity, because the objects no longer exist, or because it has been improperly constituted or otherwise, the trust property will be still legally owned by the trustees. However, the beneficial title results to the settlor. You see, equitable benefit or beneficial interest cannot remain in the air. This is what Lord Wilberforce means in the Vanderbilt case when he says equity abhors a vacuum. In other words, if there's no beneficial owner of property, equity will find an owner, most likely under a resulting trust, which will usually be the original owner. So, following the failure of a trust, the beneficial title is left hanging, which leaves us with three possibilities. Number one, the property belongs beneficially to the trustees, and this can't happen, otherwise it would destroy the very foundation of equity. Two, the property goes to the Crown Bonaventia, and this can happen, but the Crown won't take the beneficial title if there's someone with a better claim. Or three, the property reverts to the original settlor. So now let's look at some cases, starting with re Diplock. So in this case, money was left for such charitable institution or institutions or other charitable or benevolent object or objects in England as may in their absolute discretion select. This was held to be void as the word or phrase benevolent objects were not necessarily charitable, so the trust failed as a purpose trust. This case involved quite a lot of money, like £250,000, and this undistributed money was held by the trustees on resulting trust for the residuary beneficiaries. Basically, any charities which had not spent the money they'd received from the failed purpose trust were required to repay it. Okay, so now let's look at the second case here, Ames settlement from 1946. In this case, £10,000 was settled to a man on the occasion of his marriage. Later, the marriage was annulled due to lack of consummation, which had the legal effect of declaring it void ab initio. In other words, legally, the marriage never happened. So the court found that the £10,000 was held on resulting trust for the executors of the settlor's will. Okay, so now let's look at the Air Jamaica case. Now, in Air Jamaica and Charlton, a pension scheme operated by the employees of the national airline held contributions made by the employee and employer in trust for the benefit of the employee. The scheme, which allowed widows' benefits, was held void for perpetuity as there was no requirement that the widow was alive in being at the time of the settlement. So, there being no statutory provision for the wait and see rule, under Jamaican law, the possibility that a benefit might not vest until more than 21 years after the death of the employee was sufficient to invalidate the scheme. It was held by the Privy Council that each individual's pension fund was a separate trust, which was formed at the time that the person joined the scheme. Each of these separate trusts failed with the result that the accumulated contributions were held on resulting trust for the settlers. The contributions made by the employee were held on resulting trust for him or her, and the company's contributions were held on resulting trust for the company. And finally, we've got this case of St Andrew's Lawn Tennis Club. So, in this case, land was held on trust, which was used by a tennis club, an unincorporated association. In fact, it seemed as though the trust here had no beneficiaries. The trustees had the power to allow the land to be used as a tennis club and to use any money raised from rents of the land for the associated church, but it appeared to be a non-charitable purpose trust. The trust was held to be invalid for perpetuity. Accordingly, the land was held by the trustees on resulting trust for the estate of the original settlor. Okay, let's move on now to failure to declare the trust. So, where property is transferred to another on express trust, but there remains some beneficial interest in the property that is not dealt with by the declaration of trust, that interest results to the settlor. So if you transfer property on express trust but don't say to whom the beneficiary is, then the property is held on resulting trust for the settlor. This is something that Lord Upjohn makes pretty clear in the Vanderbilt case. He says that if A intends to give away all his beneficial interest in a piece of property and thinks he has done so, but by some mistake or accident or failure to comply with the requirements of the law, he has failed to do so either wholly or partially, there will, by operation of law, be a resulting trust for him of the beneficial interest of which he had failed effectively to dispose. Where money has been left for the benefit of persons who have died, and there is, due to the imperfect drafting of the trust instrument, no provision for the vesting of the trust property will result to the settlor or settlers. For example, take the case of the Trust of the Abbott Fund, so Smith and Abbott, from 1900. Okay, so in this case, money was raised by public appeals to provide for two elderly deaf ladies after their own trust fund disappeared. Following the death of the two ladies, the surplus funds were declared to be held on resulting trust for the donors. And we've also got this case of Gillingham Bus Disaster Fund from 1958. Here, a bus drove into a column of Marine cadets, killing 24 and injuring others. The mayors of the local towns made an appeal for funds for defraying the funeral expenses, caring for the boys who may be disabled, and then to such worthy cause or causes in memory of the boys who lost their lives, as the mayors may determine. Around £9,000 was contributed, of which about £2,400 was paid to the victims of the disaster. The remaining £6,600 was not needed for the funeral expenses or caring for the victims of the disaster. So the court held that the money could not be applied to prey, i.e. to charitable causes, as the appeal referred to worthy causes which were not exclusively charitable. Accordingly, as a trust for an abstract non-personal purpose, the trust failed. So the court held that the money was held on resulting trust for the donors and ordered an inquiry to be made into the identity of the donors. It's also interesting to note that in this case, where there were such a large number of donors, some of whom may have given small amounts of money or given, anonymously, the court did not consider that the resulting trust would fail for administrative unworkability. Now, we've also got to take a look at trust for the benefit of a person for a particular purpose. So in cases where a trust is for the benefit of a particular person and there is an attached purpose, the purpose will be construed as the motive for the gift and will not prevent the beneficiary from taking the benefit after the purpose is exhausted. For example, in the case of Re Osobar, a house was bequeathed to a widow on trust for the maintenance of herself and the education of the daughter up to university grade. When the daughter finished her university education, her father's heirs claimed that the trust objects were exhausted and the house was held on resulting trust for the residuary beneficiaries. The Court of Appeal held, however, that the trust was for the benefit of the widow and the daughter, and the purpose was the motive for the gift, not a binding condition. As the widow of the testator had died, the daughter was the sole beneficial owner of the property. These gifts do not therefore become resulting trusts for the benefit of the settler when the purpose have been completed or they are no longer possible. They remain express trusts for the benefit of the beneficiary. Okay. Now, when an unincorporated association is wound up, a question may arise as to how any surplus assets are to be disposed of. In some circumstances, the money will be held on resulting trust for those who have contributed or to the members at the time of the distribution. For example, let's take a look at this case of West Sussex Constabulary's Widows from 1930. So in this case, the rules of the fund excluded any beneficial interest on the part of the members. So when the West Sussex Constabulary ceased to exist, the fund was automatically dissolved. The former members, realising they had no power to deal with the property for their own benefit, thus convened a meeting to amend the fund's rules. On application to the court, the Judge Goff found that the meeting was a nullity, as it was held that the fund had been dissolved. The money subscribed by members and raised by coin collections and fundraising events was held bona vacantia, and money donated for the purposes of the fund was held on resulting trust for the persons who contributed to the fund. So, as property held by unincorporated associations is currently interpreted by the courts, if the property is held on trust for purposes which are beneficial to the members, then they are regarded as having an actual or potential, depending on the rules of the association, beneficial interest in the property, and it will not go back to the providers on the dissolution of the association. But if it is not possible to interpret the property as being held for the benefit of the members, it will either be held bona vacantia if it has been acquired in circumstances, where the donor renounced all beneficial interests, those things like coin collections, member subscriptions, fundraising events such as lotteries and things like that, or it will be held on resulting trust for the donor. So yeah, that's about it for the type B resulting trust. If you've got any questions, please drop them below, and also check out my personal YouTube channel here, and also check out my socials too. Anyway, I shall see you soon. Goodbye.